If you are using AI to create content, we're talking text, images, video, do you actually own the rights to that content? Today on Expert Connections, we have the U.S. Copyright Office's latest report on AI and copyrights. Expert Connections starts now. A big update from the U.S. Copyrights Office on how to protect your content when AI is a part of your creative process. Welcome to Expert Connections. I'm Julie Holton Smith. Today on Expert Connections, we are joined by attorney Lindsey Mead of Foster Swift to help us break down the U.S. Copyright Office's latest report on AI and copyright. Lindsey, welcome to the show.
Thanks so much for having me, Julie. I'm really happy to be here.
Lindsey, I know this is a topic that you have been closely following and we've been talking about a lot. As the owner of a content creation company myself, very interested in what you have to say on this latest update. And I know a number of other businesses will have a big impact from this. So first of all, for business owners who are using AI, especially tools to create content, can they actually claim copyright over the products they create?
You know, I already feel like such a lawyer saying it depends, but it does depend in this case. And really, for so long, the crux of copyright protection has been that human creativity and originality element. So with the existence of AI tools and technology now being able to generate a starting point for humans to then create something new off of, this is an emerging concept, and the U.S. Copyright Office really had to respond. So just a couple months ago, the Copyright Office recently published part 2 of what is going to be a 3-part series on how they're going to address AI matters. And the second part is all about copyrightability. So as an overarching summary of it, the Copyright Office says that copyright protection may be available for works where an AI tool is used, but only if that tool is enhancing human expression. So, however, for works generated entirely by AI output, which you can imagine through prompting or asking it to create an image from scratch, that in that particular case is not going to be protected. And it's because in the Copyright Office's view, an AI tool would be the author in that case and not a human. And copyright protections are supposed to be reserved exclusively for human authorship. So it's the office's position that copyright law cannot and will not apply to works made predominantly with artificial intelligence.
Okay, so that in and of itself is pretty clear cut that the Copyright Office says AI cannot be an author. I cannot go onto ChatGPT right now and have it create for me a novel and then copyright that myself as if it's my own work. But what does this mean for people who are using AI tools for brainstorming or, to help them kind of come up with some, maybe you're hitting that writer's block or you need help drafting something. How does this impact that?
Yeah, it's all really finicky with this term author. And the Copyright Office has at least defined that term before. And by definition, that is, an author is simply the creator of original expression in a work. So noticeably, that definition does not say a human person. And we know, for example, in cases where a limited liability company or a corporation wants to protect their intellectual property, they are permitted to be the owner of a copyright. So it is kind of a gray area because a company cannot be a human creating something new. But in those cases, they find that a human still has to be the author that then assigns or transfers their work to an entity. So it's considered a work made for hire in that context. And when we're looking at how AI can really integrate with this, it's still that human authorship would have to be the who and what at the center of copyright protection. So in the example that you gave, asking ChatGPT to create an image, a stock image of a cheeseburger, for example, the AI tool did all of the work. And so a human did not design or create that. They're asking the AI tool to create it from scratch. However, I would say when you brought up the idea of brainstorming, that a person using AI to generate ideas that they then operate separately from to create something new, that would be lower risk. And it depends on the situation, but I'm not so sure the AI tool would even be relevant in a brainstorming option, because in that case, AI is inspiring work that is new to be generated by a person, not so much I ask the AI tool to make something that I want to claim as my own.
Okay, so let's dig in a little bit into that gray area, that like blurriness of
Yeah.
what how to define author. So here's an example, and I know is being done locally. So let's say someone is creating using AI to generate images, and then turning those
Hmm.
images into stickers or putting those images then on some other tangible product that then they're selling. What is that person? Is that person in a gray area on whether they can even be doing that at all?
If you're doing it for your own purposes, if you're asking ChatGPT to answer a question, it's blurrier. This is really, the report is exclusively about someone who then wants to protect that image. In terms of if you're permitted to do it, again, gray area. I feel like I'm in a cyclical box of just saying it depends, but it's true because we know, for example, at least with ChatGPT's case, that there has been multiple legal actions brought against OpenAI, the creator of ChatGPT, because OpenAI has not been fully transparent about what information they use that AI tool to be trained on and to then create outputs from. So, for example, a person who used ChatGPT specifically to create a sticker, it's possible that the images ChatGPT compiled all together to then create that new image came from previously copyrightable sources. So technically, for example, George R. R. Martin's case is really kind of the hot button topic because an end user prompted ChatGPT to write a new version of the last book of Game of Thrones because they didn't like the ending. And it used all of the characters, the world building, the ideas that were original to George R. R. Martin and various other authors. So in that case, it isn't permissible to use someone else's copyright material without their consent to create something new. And in this case, with some of these tools, they are not very transparent about what they use to create what then that end user receives as an end product, if that makes sense.
Yeah, and it'll be really interesting to see how this new rule will affect some of those ongoing court cases. I know one that I've been watching is the case that New York Times has brought against OpenAI, the creator of ChatGPT. And
Yeah.
of course, the New York Times alleges that the tech company is exploiting the newspaper's content without permission or payment. And I think there are a lot of cases out there where there's content on the internet that might be behind a paywall, for instance, like the New York
Right.
Times, and by going to ChatGPT instead of directly to the source, maybe there are questions about getting around that paywall, and so there are
Yep.
copyright, infringement allegations there, which is really interesting. And of course, we want to make sure that our businesses stay protected and that they're not, then using some of that, copyrighted information that they might be then getting from ChatGPT. Is that a concern, Lindsay?
Certainly. And I think, there are apps out there that are a bit more transparent about we've only pulled from things in the open domain. We've only pulled from stock images that have an open license where anybody can use them to fuel our algorithm. And I think I would caution people against using any tool that doesn't have a clear, transparent um, disclosure about where they got their information from. Because in something like ChatGPT, where it's accessible to literally anybody, it's not necessarily the case that OpenAI went behind the paywall on New York Times' website, but it's possible that an end user like you or me copied and pasted an article in there and said, summarize this. And now ChatGPT has that permanently in its database because some random person somewhere in the world chose to be the one technically violating that copyright, if that makes sense. It's all
Hmm.
very tricky, and the liability of who's to blame is murky until these cases are decided.
I can see why there's so much gray area. There's so much for, to figure out here. I'm glad I'm not the one who has to figure this out. What should companies be putting in their contracts, or policies in order to protect themselves? We always talk about how sometimes like our greatest asset, but also our greatest weakness at times can be our human, our employees, the humans in our
Yep.
businesses. So should businesses be putting something in their policies or contracts to safeguard the business from employees or be teaching them? What do we need to do with this as far as our employees are concerned?
Sure. There's plenty of options available, both like from an internal organization standpoint of how to protect their people representing them, as well as what to look out for with vendors that they may think about bringing in somebody who's made this new AI tool and they don't want to use ChatGPT because it's not as transparent as this vendor is being. And there are plenty of things that people could implement to at least monitor and regulate and understand use. And I think on the internal organization facing side, these are often structured as an AI use policy for employees, which would essentially manage their use of AI at the workplace, and also amending if you already have a pre-existing cybersecurity policy to really account for how generative AI has opened up employees and the organization to new data privacy issues and cybersecurity risks. So the AI use policy would be essentially exactly as described. It's going to allow your employees to understand what they can and cannot use at work and the guidelines for how to not upload, for example, a confidential document into something that is not protected. And in the same breath, a cybersecurity policy is going to look vastly different depending on the industry that a business is operating in, but these often include things like incident reporting procedures or guidelines for how employees can use their approved tech at work and risk management procedures. But with a vendor, it's going to look totally different because most likely it's going to be a contract between the two parties. And in this case, you're really going to want to look at really core contract provisions like confidentiality clauses or limitation of liability provisions. And this is because we want to know who is to blame in the case of confidential information that you thought would be protected by this AI tool getting out there, or how much money are we going to limit in terms of liability exposure if a cybersecurity incident happens. So those are really, of course, every contract provision and in a contract attorney's perspective is going to be important. But I would say from, company to company assessing their contract, those are two that are really crucial when it comes to Gen AI.
And in the AI world, we talk a lot about how the current generation of AI tools is really heavily focused on content creation,
Yeah.
brainstorming, whether it's design or text written content. And so I'm wondering, Lindsey, from your perspective, how do you see this affecting industries like marketing and design, artists, the artist community over the next few years?
Yeah, it's tough to imagine where it's going to go because AI has already changed so much. And generative AI capabilities are vastly different than our predictive text features in our phones or our maps knowing that we're leaving work and heading home. So it default sets us to that route. It's already doing things that I think people did not imagine possible. And for folks specifically in content creation spaces, I think they have to have this balancing act of, on one hand, some clients are going to appreciate that individual people and artists are creating content for their business or their personal needs from scratch. And on the other hand, you're going to have clients that are expecting some type of AI tool to be integrated into your practice to reduce costs, to keep things more efficient. And so, it's really going to be, unfortunately, in the business's discretion to decide how they're going to implement these tools and to be very cautious about doing so. But in the copyright context specifically with this report and what I think it is suggesting to folks in these industries, it has explicitly committed the Copyright Office to monitoring this evolving technological landscape as things continue to progress and change. And it's open to issuing new guidelines if it's just impossible to imagine a world without Gen AI's integration. But I will say personally, for folks that are really excited about generative AI, I understand that this stance that the Copyright Office has taken may seem limiting. But in the same breath, especially for people that are in content creation, for the artists, some people feel like art is not something that technology should integrate into. And the other side of the coin could be that the Copyright Office is really serving as the last line of defense to human authored art. So I think that's just as interesting, if not, more important to people in that industry.
I encourage you to check out Lindsey's blog, fosterswift.com, also at michiganitlaw.com. She has broken down even more a case-by-case analysis for AI-generated works, prompting AI tools, and a look at that and how that is impacted by this latest decision and the recommendations on AI and copyrightability from the U.S. Copyright Office. Lindsey, thanks so much for being on the show.
Yeah, thank you so much for having me, Julie. I really appreciate it.
And that is all for this episode of Expert Connections. Stay tuned. We will link to more videos from Foster Swift as it relates to our legal connections, as well as our AI connections. I'm Julie Holton Smith. We'll see you over in the next video.